Next, I feel utmost delight and pride in having our chief guest, Honorable Minister Sir. Sir is a cabinet minister in the government headed by Honorable Prime Minister Shri Narendra Modi ji. Sir is an advocate of multi-stakeholder approach to make internet governance more democratic. He has been championing the cause of free and open internet, which is easily accessible to all. In the capacity of Minister of Law and Justice, Sir has played an active role in speeding up the establishment of fast-track courts in India and for ensuring speedy justice to people. Sir, your work has been commendable. I welcome you to the Second International Conference on Mediation and request you to kindly address the August gathering. Sir, please.
Mr. Vice Chancellor, Professor P.C. Joshi, Honorable Justice Vipin Sanghi, Mr. Justice Deepak Mishra, former Chief Justice of the Supreme Court of India, Mr. Asutosh Mishra, other distinguished participants, ladies and gentlemen. I'm sorry I had to reschedule the entire participation of mine because at 5 o'clock I have to attend a cabinet subcommittee urgent meeting on the challenges we are facing. Therefore, after speaking, I will seek your indulgence to leave. Yes, we are indeed meeting in very challenging times. These times are not entirely created by us, but its consequences have to be handled by us. Sometimes I say in lighter vein, when there is a complete lockdown or disruption, the country is operated because of the departments I handle, the communication, the IT, the postal, the internet, the mobile phone. And today's virtual interaction is also a great indication as to how technology is helping us exchange our views and ideas. I'm very happy to know that now even political rallies are being held virtually. Therefore, the digital world is helping us interact. That is indeed a new use of technology which we all must commend and appreciate. It is very exciting and encouraging to note that the university, along with Samadhan, is holding this very timely interaction on mediation. Professor Vice Chancellor was talking about the role of divine forces in mediation, the tradition of India. In course of my journey in the entire country as a political activist over the years, I have noted with great assurance the institution of punches is still working in remote parts of India. We are who the lawmakers or administrators still don't give them the credence which they deserve. I always believe that the sanctity and the role of a mediator in the shape of the punch in the village or in a group of village is still a very, very powerful institution which you need to strengthen and take good use of them. I'm given to understand the Grammy Nyaya framework. There is still a provision for mediation by these rural bodies. And I would urge the Delhi University or Samadhan that there must be a separate discussion on how the use of these institutions can be met more effectively. Now, coming to the issue of today, taking a cue from the Vice Chancellor, Mr. Joshi, I would also like to go a little into the cultural history of India. Lord Shri Krishna also tried mediation to avert Mahabharata. And though there was a perceptible bias in favor of Mahabharata, in favor of the Pandavas by the Kauravas, Yet he tried to be a completely neutral umpire, offering Paj Gaon, but even that was not possible. And one of the greatest initiative of mediation failed, and Mahabharata happened. In recent times, if I can recall my own experience of being the lawyer of Ram Lalla and Hindus in the Allahabad dispute of Ram Janmabhoomi, which we won in the Supreme Court, I could not argue because I had become the minister. There was a very effective intervention by the Supreme Court also to get the dispute resolved through mediation. And some retired judges also were involved, some good mediation experts were involved, including some very powerful religious spiritual leaders. Unfortunately, it could not succeed. What I'm trying to drive home at, ladies and gentlemen, is that Indian society also has a habit of litigating. कोर्ट से फैसला हो जाने दीजिए, हम स्वीकार कर देंगे. That is indeed a great psychological roadblock, because whenever I interact in a gathering like this, my approach is always a little practical. What is to be done and what is doable. Unless we have a proper balance between the ideal and the doable, the law cannot deliver. Therefore, the first question which you all need to address is why mediation is not succeeding in India, in spite of such powerful, inspiring legacy of our cultural tradition, wherein mediation occupies such a central role in the social, psychological, and emotional appeal of Indians. That is a question not very free from difficulties, but that is a question which requires answer. I would believe that of late, this tendency to litigate has taken very firm roots, because the respect which the institution of judiciary commands, people believe this would bring their dispute to a closure, which mediation may not. The first question is to really disabuse our common perception from this stumbling block. The second, obviously, lawyers are also there in mediation. How far they helpful? Today, I would like to share some of my views because it's some time that I have been handling the portfolio of law ministry. There is a provision of Section 89 CPC, making a provision for that, right from Marriage Act to the company law proceedings to the consumer acts. There are many statutory enactments of various separate laws making compulsory provision for mediation. But whenever we review and audit these issues, it is very important to address the most important question: why are they not succeeding? You make provision in law, you make very elaborate provision, but there must be a proper balance between its actual delivery on the ground with the legal architecture in the place. Therefore, if Samadhan is exploring all these potential, there's a need to seriously reflect as to what has been the result of various mediation proceedings, provisions which are enacted in separate laws. I think that is very, very important. And if I see in view the data available, one area where it has shown some promise is in matrimonial disputes. Particularly, Delhi High Court and Delhi centers have played a very, very crucial role. It is mind-boggling for me as a law minister. Why should matrimonial dispute stagger for so long, from maintenance to other issues? If they cannot live together, why can't there can be a very I would say, flexible solution for a divorce to bring the suffering to a close. These questions nag me, and therefore I'm flagging those concerns today. And I would like to urge this august body of interaction to kindly reflect upon these issues so that we can further build upon that to find a very robust solution to these problems. Let us take the case of National Legal Service Authority Act. There is a proper provision for mediation there as well. I also tried to know as to what has been the result of these efforts. In terms of statistics, they are impressive. But when I tried to know the quality of disputes being brought to a close by mediation, I would say I'm not very impressed. How should I explain it? If you see the Legal Service Authority Act, there is a provision of public services. And most of the Lok Adalats, substantial part of it, if it is not India figure, are settling the issues of mediation through about grievances relating to the public services. Bijli ka bill hai, motor vehicles claim hai, a variety of other things. I was just trying to know the number of last year. This year is yet to come. April 2019 to March 2020, the total cases settled for mediation are 94,865. And I was very impressed when I saw that more than 5,096 are judicial officers as mediators. Lawyers mediator is 8,249. And other mediators are also about 2,881. It is good. I'm happy about it. But this will make sense only when the quality of dispute is of a more substantial nature, except relating to public service grievances or petty crimes, which is compoundable, is also settled there. I'm given to understand. The main challenge for us, ladies and gentlemen, in ensuring the success of mediation is how can disputes of importance, disputes of significance, and disputes which touch the core of our justice system as an alternative dispute resolution mechanism are settled through mediation. That is a challenge, not very free from difficulty. And therefore, I repeat, we need to reflect very honestly and seriously that in spite of the mandate of Section 89 CPC, the 345 specific laws stipulating a mandatory provision for disputes, settlement through mediation, have not given us the desired results. Recently, you may have noticed that we have enlarged the ambit of commercial dispute cases. And even for a dispute of up to 3 lakhs, we need to get the matter referred to a commercial court system. When this law was being settled and decided, I insisted that we make it mandatory to have mediation. And since we have a very robust mechanism of mediators under National Legal Service Authority Act, I suggested, since they are set up in various parts of the country, I suggest mediators be used for the settlement of these disputes as well, petty disputes, commercial disputes, non-payment, etc. And therefore, when we were finalizing the law, I insisted, unless there is emergency need for some interim measure, injunction, etc., for a very powerful reason. You are obliged to go to the process of mediation. Of late, I have been auditing it, what has been the result. And I would say, not a very satisfactory. There is a reluctance to go even to that process of mediation. There can be a variety of reasons. Therefore, if we have to make mediation successful in India, we have to think out of the box. And unless we are able to address the simmering challenges as to what is making mediation not a very successful instrument, I'm afraid we'll not be able to really make mediation a big part of India's justice delivery and dispute resolution, which all of us want. I want to make it very clear. I should not be misunderstood. I'm a great supporter of mediation. India needs to have a powerful mediation ecosystem. What we have done, and now what I propose to do, I would like to briefly comment here. You all know that we had set up a Sri Krishna Commission to recommend upon arbitration and conciliation. A very important recommendation came where Justice Ravindran was there, Sri Krishna was the chairperson, and many other eminent jurists like Justice Mr. Narasimha, the senior lawyer eminent, Indu Malhotra, who had authored a book on arbitration, etc., were part of that committee. They have made recommendations, and we have finalized those recommendations. We are going to bring it into effect very soon. Namely, we have to set up an Arbitration Council of India, headed by retired judges of India, retired Supreme Court judges, and other eminent people will be there, who will be grading the institutional arbitral institutions of India. How are they performing? Because grading of arbitral institutions is very important. And if you have to make arbitration a successful instrument, it is very important we must have institutional arbitration in India. Today, ad hoc arbitration is going on. For institutional arbitration, I try to the number. That number is about 39, 40 in the country. If you ask my view, I will be happiest if there are 400 arbitral institutions in India, manned by quality arbitrators, giving results in time. I'm very keen. We must develop in India a good set of arbitration professionals, lawyers, who are only dedicated in the field of arbitration. When these arbitral institutions will be graded by the Arbitration Council of India, its performance shall be judged upon all these parameters. And ultimately, whenever a court has to appoint an institution, the grading of these arbitral institutions by the Arbitration Council of India will be an important factor. And the reason I was very keen for grading was that if an arbitration institution is doing well, its professionals are good, the arbitrators are good, the delivery of the dispute settlement resolution is done in a defined time frame, people will rush to those institutions. Let's go there. I always say, and this I am saying with respect to all the honorable judges present here, there are retired judges and arbitrators, but there are also a clamor for those retired judges who deliver their award in a defined time frame, and obviously with full regard to propriety and integrity. In a similar way, if an institution of arbitration certified by the Arbitration Council of India develops, I will see a big growth of professional arbitrators in India, which I want to encourage. The reason as to why I gave you this background, ladies and gentlemen, is that mediation is permissible under Section 30 of the Arbitration Act. And through mediation, if a settlement is done, it also acquires the legal credentials of an award, enforceable as such. I would really commend that and I'm very keen, our government is very keen, so is the Prime Minister, that India must become a big hub of international and domestic arbitration. And India has all the credentials, being a big country and a big economy, governed by democracy and rule of law. In that view of the matter, ladies and gentlemen, if mediation centers are also developed along with an arbitration institution, it will be a great, I would say, boost for mediation movement in the country. Yes, we are working on a separate dedicated law for mediation in consultation with the Supreme Court system. That is a work in progress. My team is working. And I will be very keen to begin stakeholder consultation soon after the initial architecture is in place. But my final take, Mr. Vice Chancellor and other distinguished panelists present here, including honorable judges, that we must always strive for a mediation which is workable. We must strive for an ecosystem which is deliverable. And we must strive for an institutional system which inspires confidence and trust. If we are able to address those challenges, including the enforceability, then I think India will have a robust mediation ecosystem as well as the institutional arbitration is rising in India. And lastly, we should never lose sight of the great institution of our panches in the Gram Panchayats, who have done such an excellent role of mediators for the last so many generations and centuries. And yes, we may have reservations, but Indian society, as the Vice Chancellor rightly pointed out, also trusts the spiritual architecture of India's dispute resolution. हमारे भगवान ने हमें कह दिया, मुझे मानना है. I think there must be a trust also for that element. These are some of my general views, Mr. Vice Chancellor, distinguished judges and participants, which I thought I must share. Let me conclude with this hope. We have to ensure mediation succeeds in India, and we have to work together in that regard. I'm sure today's powerful interaction would help facilitate achieve that end. With these words, I seek your indulgence to leave. An urgent meeting is just waiting for me. I have to rush there. Thank you. Namaskar. Jai Hind.